Mike Davis of the Article 3 Project. Mike, you were outside the U.S. Supreme Court all day today reporting on this, listening to the arguments. What was your main takeaway from the 2.5 hours of oral arguments?
Listening to the oral argument today, especially listening to the Chief Justice and Justice Kavanaugh's questioning, I think that President Trump is going to win, maybe 5-4, maybe 6-3, depending on what Justice Amy Coney Barrett does. But a majority of the Supreme Court is going to hold that a president of the United States, any president of the United States, is immune from criminal prosecution for their official acts, not their personal acts, their official acts. And then the Supreme Court is going to remand this case back down to D.C. Obama Judge Tanya Chutkan, and she's going to have to do what she should have done in the first place, which is hold an evidentiary hearing to determine whether what Jack Smith alleged in this January 6th indictment against President Trump, the allegations that are in his personal capacity versus what are in his presidential capacity. For example, thinking about firing the acting attorney general of the United States is in this criminal complaints by Jack Smith. That is clearly a presidential act. That's clearly an official act. And so that would mean that President Trump would be immune from that. And what's so important about this case, and I think the justices got it, is that if you don't hold that a president of the United States is immune from criminal prosecution for their official acts, this is going to destroy the presidency and therefore destroy our country. This would mean that the Trump 47 Justice Department could charge President Obama for capital murder for his extrajudicial drone strike on 2 American citizens, including a minor. The Trump 47 Justice Department could charge President Biden his illegal mass parole of 10 million unvetted illegal immigrants into our country and the resulting crimes.
Well, Mike, the ruling on appeal from the district and the D.C. Circuit was that absolutely no immunity applies to a president's core official acts. First of all, did you believe that this was radical and extreme? And two, why specifically did the justices take exception to this ruling in their questioning?
I think these 4 judges, these 4 ladies in the lower courts who ruled that the president is not immune ever from criminal prosecution for his official acts, I think they didn't use their brain, because the president of the United States is immune from civil prosecution for his official acts under the Nixon case from 40 years ago. Federal judges are immune from both criminal and civil immunity, from liability, criminal and civil liability for their official acts. So are members of Congress. Why the hell wouldn't the president of the United States? And the only reason it hasn't been established that the president is not immune from criminal prosecution for his official acts is because we've never had a former president charged until President Biden and these Democrat prosecutors brought this unprecedented lawfare and election interference against President Trump, including these 4 unprecedented criminal indictments for non-crimes. And so I think the justices are very aware of what's going on. That's very obvious from the questioning, and this is going to backfire spectacularly on the Democrats legally, financially, and politically.
Well, Mike, you mentioned a crucial distinction that was highlighted in the arguments, the difference between official and non-official actions. So let's say everything you're predicting does come to fruition. They side on the side of Donald Trump. It gets sent back to the district court, and Tanya Chutkan, the judge, has to hold an evidentiary hearing. Were Trump's actions that are under the microscope right now, would they qualify as official acts under the presidency?
Some would and some would not. And that's the whole point of the evidentiary hearing. And you have the Fisher case, where 2 of the 4 criminal indictments, criminal charges by Jack Smith on the January 6th case against Trump relate to obstruction, a post-Enron obstruction statute that the Biden Justice Department has contorted, politicized, and weaponized against Trump and his supporters. That's likely going to get thrown out by the end of June. So 2 of 4 of Jack Smith's cases are likely going to be seriously wounded. And then after this presidential immunity, another 30% of Jack Smith's case is going to be gone. So Jack Smith, at the end of this, might have 20% of his case left. And guess what? They're not going to be able to get Trump tried before the election. Trump's going to win. He's going to dismiss these charges as he should. And then he should open a criminal probe on these Biden Democrats, President Biden, and these Democrat prosecutors and judges and witnesses and officials who have clearly run a criminal conspiracy under federal law to violate Trump's civil rights, the civil rights of Walt Nauta, the civil rights of the co-defendants in Georgia, the civil rights of the co-defendants of the defendants in this new Arizona case. This is obviously a criminal conspiracy by President Biden, his White House, his Justice Department, and these Democrat AGs and prosecutors, and there must be severe legal, political, and financial consequences.
Mike Davis of the Article 3 Project, thank you so much, sir. We appreciate you joining us here